right, why don't we get started? My name is Ron Layton. I'm a United States District Judge from the Western District of Washington, a member of the Court Administration and Case Management Committee. The panel we have here is the panel on implementation. We're here to discuss the means and methods by which the judiciary seeks to disseminate information and at the same time protect privacy. The committee, when I assumed responsibility or was given responsibility by Judge Radke for the implementation side of the aisle, I said that this is a committee in need of a job description. When the other committees identify a policy, we would go to work in developing an appropriate method for achieving that objective, easy. As I have drilled a little deeper, I've come to the conclusion that just as the competing legitimate interests of the courts and its constituencies make policy making difficult, so too these important and oftentimes mutually exclusive interests make it difficult to select an appropriate method to best achieve what would otherwise be deemed a viable goal. And to help us navigate this, through these choppy waters, we've assembled an interesting and informed panel of speakers. To begin, we're going to ask Joe Cecil, as a senior researcher for the Federal Judicial Center, to talk about a survey or a study that was just conducted by the FJC on unredacted Social Security numbers within the federal judiciary over the last, over a 2-month period. Joe?
Thank you, Judge Light. Well, this is the implementation panel, and one of the things that we were asked to do is determine the extent to which the protections in the rules to guard against improper disclosure of Social Security numbers has in fact been properly implemented. You'll recall that the attorneys are instructed to redact the Social Security numbers upon filing. Our study is essentially the study that you heard described by Peter Wynn earlier. It was a Google search of all the documents filed in federal court, district court, and bankruptcy court, all the documents filed in November and December of this year. And we're looking for something that is very specific. We were looking for a pattern of numbers that follow the pattern that the Social Security numbers have. The 3 digits, hyphen, 2 digits, hyphen, 4 digits. The result of that search revealed about 2,900 Social Security numbers in all the documents filed, 10 million documents filed during those 2 months. Now, the rules themselves have some exceptions for filing of Social Security numbers, and it looks to us like probably about 5 million of those Social Security numbers fall under some of the exceptions. They were either numbers that were from some previous state courts proceedings that were restricted. Some of the documents were in fact filed earlier than December of 2007. But in the end, we got down to 2,400 Social Security numbers that looked like they're still knocking around in the system. Numbers that should have been redacted. 2 final points. First, we're talking about 2,400 documents. Some of these documents have more than one Social Security number. In a large commercial bankruptcy, we would find documents that listed Social Security numbers for all of the employees that worked at the business that went bankrupt. We'd find documents and financial account numbers for investors in a failed enterprise. So some of these documents are really rich in Social Security numbers. We estimate about 20% of them have more than one. And then the last thing is that when we think about the 2,400 Social Security numbers that still exist in the records, you have to keep in mind, we're talking about 10 million records that are filed in court. So really only 1 out of every 3,400 documents that we examine had a Social Security number. Again, the study is in the agenda book, about the middle of the agenda book, and I'll be around for the rest of the day if you have any questions. Thank you.
Joe, thank you. First member of the panel to speak is Sha Qian, as she is the Chief of the Public Access and Records Management Division at the Administrative Office of the United States Court. Prior to joining the Administrative Office, she worked as a management consultant for the EDS Corporation and as a Foreign Service officer. Michelle.
Thank you, Judge Layton. Good morning. I would like to begin by giving you a very brief overview of the Judiciary's Electronic Public Access Program, the mission of which is to facilitate and improve public access to court records and court information. Although I am here today to discuss access to court records through PACER, I would be remiss not to mention that the program is broader and encompasses the Judiciary's public websites, courtroom technology, and noticing. PACER was established in 1988 as a dialogue service. In the last decade, through the implementation of CMECF, that would be the electronic case filing system, PACER has evolved into an internet-based service. In other words, PACER is a portal to CMECF, which is integral to public access. PACER provides access to various reports, court dockets for more than 30 million cases, and over 500 million, that's 500 million documents filed with the courts. This is, by any standard, a massive collection. During 2009, the program reached a new milestone with over 1 million registered PACER accounts. In any given year, approximately 1/3 of those accounts are active, and many accounts do in fact have multiple users. PACER has several categories of users. They are fairly discrete. Fully 75% are from the legal sector or litigants. 10% are commercial users. Approximately 5% are background investigators, which we have sorted out from commercial institutions. 2% belong to the media, and 2% represent academia. As I mentioned, PACER users are registered. All PACER access requires user authentication through the use of a login and password. Usage information is collected and stored, as set forth in the PACER Privacy and Security Notice on our website, as well as the PACER login banner. This provides a deterrent to those who would use PACER to obtain information for nefarious purposes. I can tell you that the Administrative Office does respond promptly to subpoenas for information on PACER usage. Information that we have provided has been used quite effectively in the courts. The Judiciary proactively works to strike a reasonable, reasoned balance between providing public access to court files and protecting sensitive information, as evidenced by the evolution of national policies, federal rules, and procedures over the years. And we have not done so in a vacuum. We seek expert advice and input from all the various interested parties, especially all of you here today, and which, as we've already heard today, are often seeking different, sometimes mutually exclusive outcomes. On a personal note, I will let you know that this is just the type of territory, fraught, ongoing, seemingly intractable, that a former diplomat really relishes. Our efforts to inform the public of our policies, rules, and procedures extends to the internet. We have published extensively at the following website, www.privacy.uscourts.gov. In the interest of time, I would like to summarize just a few of the more recent steps that have been taken to protect sensitive information while preserving a high level of public access to which we are committed. In 2003, CMECF was modified so that only the last 4 digits of Social Security number can be seen on the docket report in PACER. In May 2007, the Forms Working Group, comprising judges and clerks of court, reviewed over 500 national forms to ensure that they did not require personal identifier information. Although, as Judge Morris pointed out earlier, there's still work to be done, we only found 6 forms which required that information, and those forms were revised or modified to delete those fields. Last August, the courts were asked to implement a new release of CMECF that was specifically designed to heighten the awareness of the filer's requirement to redact. The CMECF login screen now contains a notice of redaction responsibility and provides links to the federal rules on privacy. CMECF users must check a box acknowledging the requirement to comply with the rules in order to complete the login process. CMECF also displays another reminder to redact each and every time the document is filed. Judging from the complaints we have received, these changes have certainly served to heighten awareness. The Judiciary continually seeks to expand public access. An important initiative to do so was approved by the Judicial Conference last month, namely the Digital Audio Pilot, which provides access to audio files of court hearings through PACER, was approved for national implementation. During the pilot phase of this initiative, a major concern was assuring that personal information not be made available to the public through the audio files. 8 courts participated in the pilot, including Nebraska and Pennsylvania Eastern District Courts, as well as the North Carolina Eastern, Maine, Alabama Northern, Rhode Island, and New York Eastern and New York Southern bankruptcy courts. Each of the pilot courts warned lawyers and litigants in a variety of ways not to introduce personal identifiers, nor to ask questions which would elicit personal identifiers unless absolutely necessary. Lawyers and litigants were also warned that they could and should request that recorded proceedings that include information covered by the privacy rules or other sensitive matters not be posted. Of course, the presiding judge ultimately determines which audio files should be posted. A word on the use of software to redact. Algorithms can and have been developed to identify social security numbers, and they are effective in most, but certainly not all cases. Unfortunately, it's far more difficult, and in some instances not presently possible, to develop algorithms to identify other types of sensitive information, such as the name of a minor, which I would argue is far more sensitive in nature than a social security number. Be that as it may, technology is a wonderful tool. I know we use it liberally, but it is not a fail-safe, and it is certainly not an adequate substitute for filer vigilance with respect to protecting sensitive information from disclosure. I think it's fair to say that the Judiciary's national court-based efforts, which you'll be hearing more about shortly, appear to be having the desired effect, as illustrated by the Federal Judicial Center's excellent study. We really took heart that of the 10 million recently filed documents that the researchers reviewed, less than 0.03% were found to contain social security numbers. Of those, 17% had a readily apparent basis for a waiver. Upon further scrutiny, we believe that we will find more documents that qualify for the waiver for pro ses. All in all, this is very valuable information, and we will use the results of the study to zero in on lapses and address them. Thank you.
Thank you, Michelle. Our next presenter is Professor Edward Felton. He's the Director of Information Technology Policy and Professor of Computer Science and Public Affairs at Princeton University. His research on topics such as web security, copyright and copy protection, and electronic voting have been covered extensively in the popular press. In 2004, Scientific American magazine named him to its list of 50 worldwide science and technology leaders. Professor Felton.
Thanks. I would like to respectfully challenge a little bit the standard narrative about this issue. The standard narrative is that there's a long-standing tension between transparency and privacy, and that technology makes this worse. I'd like to argue that technology can be our friend on these issues in two ways. First, that advanced technology can help us to address the privacy challenges we face. And second, I'll argue that advanced technology increases the benefits of openness. So first, using advanced technology to help address the privacy challenges. We've already seen an example of this earlier in the session with the study of how many social security numbers are present in documents. And that's a valuable step. Now, of course, social security numbers, as Michelle said, are probably the easiest case because they're a very fixed pattern that's easy to scan for technically. And it's possible to find and automatically redact social security numbers in a lot of cases. But I believe that technology can be pushed a lot farther to help identify failures to redact, not as a replacement for human attention, but to augment it. And there's some simple things we can do and some more technologically advanced things. As an example of a simple practice, if a particular name or piece of information is redacted in one case document but not in another, a system could flag that at the time of filing and alert the alert counsel or the court employee who's filing that document to take another look. As an example of a more advanced use of technology in these fields, I'm convinced that advanced machine learning methods can be very valuable in helping to find failures to redact, even for difficult types of information, such as names of minor children. This is a topic on which we have ongoing research at Princeton, and we're hoping to be in a position to talk about positive results soon. So I believe that we can do a lot to help find redactions that are done wrong, and I think there's a lot that can be done in terms of how the system is structured and how users interact with it in order to make it more evident when certain kinds of sensitive information is available. So I'd also like to talk about some of the benefits of transparency, of putting documents out there for people to use. The kind of research that I was talking about into machine learning, the kind of research into different interfaces, as well as research about the extent of privacy problems in the documents of the sort that we've been doing, is only possible because we do have access to a large number of documents. We've assembled a corpus of about 2 million documents, which, by a variety of lawful means, that has served to enable our research. But many people who are itching to do constructive research along these lines have been held back by lack of access to documents. It's simply not feasible to buy 2 million documents from Pacer. That would cost too much money, as well as not really being feasible even to download them all. So access to documents has a lot of valuable purposes. And indeed, there are many new types of constructive and valuable research which will become possible when documents are available, at the very least, to researchers involved. Research on issues of direct interest to the judiciary, such as questions of judicial workload and case management. Historical and journalistic research to look at global pictures and trends across the entire judicial system, as well as development of new tools for improved legal research. I'm convinced that if and when a large quantity of court documents become available to the great minds of Silicon Valley, that we will see not long after that great new ideas, improved ways of doing legal research that really put the sort of technology that has enabled companies like Google to succeed to work on the specific problems of lawyers and legal researchers. I think there's a lot that can be done in that area, but is not quite possible today because information and documents are not as available as they could be. So if the judiciary is going to move ahead and move toward a system that is more open, makes more documents available, the next logical question is how best to enable positive uses of those documents of the sorts that I described. And I would argue that from the standpoint of a researcher looking to use these documents, there are really two things that we would like to see. First, we'd like to see bulk access to the raw documents. There's no substitute for actually having the data on which your study is going to operate. Second, I would argue for authentication of the documents by using a technology such as digital signatures, which is a kind of electronic seal of authenticity put on a document. And the advantage of doing that is it makes it self-evident that the document is authentic, regardless of from whom you received it. And that makes it possible for, say, a commercial service to provide a document to a working lawyer, and the lawyer can be sure that it is authentic because it bears the digital signature of the administrative office of the courts or some other authoritative body. I think there's a lot to learn, actually, from other branches of government, which do face not the same, but similar kinds of issues in balancing transparency against cases where information should legitimately be withheld. The executive branch and the legislative branch have been working through these issues, I think on a larger scale and in some respects than the judiciary has. And I think there's a significant amount to be learned there. Finally, on this question of how best to enable access for positive use, let me just put in a brief plug for our paper on this topic called Government Data in the Invisible Hand, which appeared in the Yale Journal of Law and Technology, Volume 11 last year. Thank you.
Thank you, Professor. Our next speaker is Judge Elizabeth Stong. Judge Stong has served as a United States bankruptcy judge for the Eastern District of New York, one of the pilot project districts. Since 2003, before taking the bench, she was a litigation partner and associate at Wilkie Farr and Gallagher in New York, and associate for Bass, Swain and Moore, and law clerk to the Honorable David Mazzone, U.S. District Judge in the District of Massachusetts. Judge Stong.
All right, thank you so much, and thank you especially Professor Capra, Judge Raffi, and Judge Rosenthal for convening this and for inviting me to participate. It's been quite an interesting experience to step back and look at these issues systematically and from the special window that we have on personal information in the bankruptcy process. What we look at in the bankruptcy arena is the most detailed, the most personal, detailed information about an individual's situation that you can imagine. And we do it at a point where they have come to the bankruptcy process for a fresh start, probably because something bad has happened. For whatever reason, not at a high point, but at a comparative low point in their lives. So the question we're looking at is not like the question of the prior panel, whether to redact, what are the trade-offs? Because that decision was made back in 2003 when the bankruptcy process adapted to the need, the requirement to get Social Security number information out of our public documents. At about the same time that we were going universally throughout the system in the bankruptcy courts in the United States to electronic filing, electronic access to information. So think about where this puts us. Disclosure drives our process. The kind of disclosure you see in a bankruptcy case is unlike anything I saw in my prior life as a big case litigator. You can file a class action against the biggest company in America. You don't have to tell much of anybody, much of anything about who you are. You file an individual bankruptcy case, as 1.35 million consumers did last year, and you need to disclose your name, your address, your dependents by age, though not by name, where you work, where you used to work, how much you make, who you owe money to, what you own. I have seen debtors take this so literally as to itemize the things in their closets. It's a pretty intrusive process. Access to this information is critical. Access for courts, access for creditors, access to the trustee assigned in the case, access to the Office of the United States Trustee, part of the Department of Justice, charged with the very important job of seeing if there is abuse of the bankruptcy system taking place. So you've got broad disclosure by individuals. You've got broad access to that information. And we put it all on the internet. We have put it on the internet because as of 2003, every single bankruptcy court, every single document, whether filed by a lawyer or filed pro se, winds up electronically accessible. And this is for many practitioners in the field of volume practice. So while I think and I assume, and I'm generally ratified in this thought and assumption, that every lawyer who files a document with a federal court does it with the care and the attention it requires and deserves. It also happens from time to time that somebody with one too many cases to get filed that day may be in a bit of a hurry. It is a volume practice sometimes. And so of those 1.35 million consumer cases that were filed last year, a certain number of them filed by counsel may nevertheless not have received precisely the attention we would like to see, and yes, occasionally a mistake does happen. So I have to tell you, I was extremely interested in seeing these numbers. 10 million documents. This is taking me back to my days as a litigator where we did document review in big cases, antitrust clearance, things like that. And I was both enheartened and concerned to see that a number as low as the number presented is the number of documents in which Social Security numbers still appear. I was not surprised to see that we in the bankruptcy world have a certain number that's on our watch, 2,244 of the 2,899. I was struck to see that filing pro se is an exemption. Because when I see a pro se, I sometimes see someone who has already been victimized in one way and may well be victimized by not having a lawyer in a very complicated process, if the court process does not attend to the needs of that case. So you take these competing factors that affect, I'll say, nearly every bankruptcy case, the need for disclosure, the need for access, the fact of electronic filing, and you get a bit of a perfect storm against which to apply a criterion that I think we universally understand should be as close to perfect compliance as we can get. Because remember what comes along with an inadvertently included Social Security number, a name, a home address. a mailing address if it's different, employment, a record of every debt that person owns. This is a portfolio of information designed to facilitate identity theft. So you attach that also to a social security number, you've got your next perfect storm. Imagine the risks. Imagine the problems. Now you're going to say, is identity theft really such a problem for people who file bankruptcy? Is that the kind of identity people want to steal in the credit world? And I'm here to tell you it happens. It happens and it's a problem. And then you have to get victimized somebody who's come to the court process for relief. Relief for the honest but unfortunate debtor. So, what do we do in our court? First of all, I think we are grateful every time we see a properly redacted document, and they usually do come in that way. The statistics are consistent with our experience. I embrace this notion, mentioned in the prior panel, of informal, anecdotal, empirical research. I think that must be a professor's way to say asking around, which is what I did. And it sounds a lot better. But I will tell you that in our court, we do not see a widespread problem. But it does not need to be a widespread problem in order to be a problem. Because when an attorney misses this, they create a potential issue, if it's not caught, that will live on that docket indefinitely. What we see anecdotally as we follow up on these situations where they're identified, for example, through the quality control process that our clerk's office, our wonderful clerk's office staff undertakes with every document filed electronically, it seems that most of the time this is a situation of staff in the attorney's office filing a document with attorney supervision, but not at the level and with the guidance that we would like to see. And so a mistake happens. How do we follow up with this? Well, we have electronic filing training. We make it available to attorneys, and we invite staff to participate as well. We have a wide open door to this training, and the more it's used, the better. From our perspective, retraining is not a mistake either. These are complicated procedures, and if you do not use them every day, you should come back, and we welcome that. We encourage it, we promote it, and not in a punitive way, and I'll get to the question of punitive in just a moment. So when we see it as a problem, it sometimes traces to staff we immediately contact through the clerk's office, the filing office, and get a redacted document on the docket, the unredacted document taken down. When you go into CMECF to file a document, as you've heard, you have to specifically check and click through a screen that acknowledges that you know you need to redact this information. Now, do we all click through, check something, and click through every time? I was recently away and clicked through to use a hotel's internet access, and did I scroll down to the bottom and say, yes, I had seen the policy? I did see it. But I think it still serves a useful purpose that every time a filer logs into CMECF, they are required to acknowledge that they are aware of this policy or they cannot go further in logging in and filing their documents. We also try to remind people in other ways. We have an ECF newsletter, and it is surprisingly interesting reading. I mean that. If you'd like to get a copy, give me your card. I'll be sure we forward one to you. It's written in a short narrative way. It's kind of fun how many documents have been filed, and we put reminders. Again, in a prose way, not just a policy, not just as a teaching thing, but reminders and information about the importance of complying with the requirement to redact Social Security numbers, not our court's policy, but a fundamental policy of the Judicial Conference. Sometimes if we see a problem come up more than once with an attorney's office, the staff will really reach out to that office and try to get to the right staff people and invite them to come in. If they're having a problem or they have a question about our procedures, we want to hear from them to make our procedures better. Finally, if it happens, and it's rare, I will say once or twice every 2 to 3 months, that we see a document in chambers or in court, often by a pro se, sometimes in the supporting documents filed with a proof of claim, which is what a creditor files together with original documents that have been scanned, describing why they should get a payment in a bankruptcy case. We see it in chambers. We are promptly responsive, either through our courtroom deputy in my own chambers, down to the clerk's office, to be sure that the problem is fixed. And that's an informal procedure, but it's a question that comes up early enough that that kind of direct intervention seems to be a practical solution. And the solution that gets the attorney's attention, nothing like a call from the clerk's office or from the courtroom deputy to say, we see something we're concerned about, can you please fix this and fix it promptly? Thank you so much. It has worked. We have not yet, I mentioned this before, gone to a framework where we do something like impose a consequence or a penalty. I don't believe it has ever been the case that we've even seriously considered taking away someone's filing privileges, for example, and I expect it will not come to that. It would take an extraordinary amount of non-compliance, I think, for us to go to that level. But in a way, and I'll end with this, this reminds me a little bit of something I learned growing up in the San Francisco Bay Area, where we were never done. It was never done painting the Golden Gate Bridge. You sanded it and painted it in one direction, you turned around, and you started in the other direction. Once the decision is made in whatever court that information of this nature needs to be excluded, redacted from documents, it needs otherwise to be available to participants in the process. I think just like the Golden Gate Bridge, you are never done reinforcing the need to comply. As a court, we should never consider ourselves done with the enterprise of making compliance as easy as possible, as plain as possible from a procedure standpoint, and as comprehensive as possible, because it's even one mistake, given the potential consequences, is a mistake we should not tolerate. Thanks very much.
Yes, Tom, thank you very much. Our next presenter is Jay Safer. Jay is a partner at Law Board Bissell's New York office. He counsels clients on commercial matters, including protection and preventative measures, creation of risk litigation plans, e-signature, e-discovery, and e-readiness, and pre-litigation analysis. Jay?
Thank you, Judge. I recently had the opportunity to participate on a committee which helped draft a proposed rule for the state courts on how to deal with private sensitive information about individuals. It's got to be remembered what we all recognize, that never have so many documents been so available to the general public that are filed in the courts and electronically. The FTC and its FTC theft identity page estimates that 9 million Americans have their identity stolen each year. In the federal courts, at least you have Rule 5.2, which has been discussed in part, and I'll get to that in a second, but think about how you would write a rule, and what would you put in it? What information would you deem to be appropriate to tell an attorney not to put in papers? How would you tell that attorney so that it was meaningful, so the attorney followed either purposely or not purposely if information was put in that page? What should be the enforcement of that? Who should be checking the documents? Should it be a clerk at the court? Should it be the judge? And what, like I said, what information? And should it be mandatory? Well, the federal court rule, like I said in 5.2, has selected information. And it has social security numbers, as you know, has taxpayer identification numbers, birth date, the name of an individual known to be a minor, and financial account numbers. I want you to try to remember that because, although briefly in my time, I want you to compare to what now happens in the state court. Keep in mind that in the state courts, the general public has access now to almost all documents. First of all, while e-filing isn't required in state courts, specifically, once you get into commercial division, e-filing becomes, in effect, a presumption. A new proposed rule under legislation in New York State will require in certain districts that any case involving commercial matters in New York County will be e-filed. In Nassau County, tort cases, and one other county to be picked. But even putting aside e-filing, what they're doing in state courts is they are scanning all documents that are filed. You can imagine with all documents being filed, how much is going to be available to the general public. And all you have to do as a member of the general public is go to various links to the court website. New York courts.gov is the main website, but there's specifically a link that is Supreme Court Records Online Library. It took a while to get that. It's called Scroll, in case you have to remember that for a test or something. Just remember Scroll. But what it does is it just makes available all these documents. So what happened was it turned out that the state of New York has no, unlike the federal courts, at least it has that rule, has no statewide unifying court rule on how to deal with the sensitive information. It's got a scattering here, a scattering for that court. They proposed a commission, proposed a rule in 2006. It did not go forward. So in sitting around looking at this, the first question was, how do you deal with what information? Well, at the city bar, I'm chair of the Council of Judicial Administration. We had a subcommittee dealing with this consisting of a wide range of people. Steve Kamen was a lawyer, Judge Soberman, the former administrative judge, Karen Milton, who was the circuit executive of the Second Circuit, and others. And we came up with 9 types of information that should be mandatory to be excluded in its entirety. I'll be quick, the Social Security number, taxpayer ID number, bank and other financial account numbers, passport numbers, driver's license number, government-issued ID numbers, other identification numbers which uniquely identify an individual, the names of minor children, and dates of birth. And in this report, which is a long name, report recommending a New York State rule requiring that sensitive personal information be omitted or redacted from documents filed in civil courts. You can see this report on the website at nycbar.org, probably the best places under the Council of Judicial Administration reports. But then what happened was that in doing the report, we looked at other states. Now, 15 other states have rules on access based on what you file. But they're all different. Some are mandatory, some are some information. In looking at these 9 areas, one question we did look at was, for good cause, if you needed to use information, certain portions of these numbers, such as the 4-digit last digits of Social Security, could be included. But in looking at this and trying to decide, does the clerk have the responsibility to look at this? We said the clerk has so much to do. That should not be their responsibility. It should be the responsibility of the attorney. Then the question came up, should this be an ethical violation? And the feeling was that it's just too hard to have this ethical violation, keep it as a court rule. Then the question was, do you have other types of information, email addresses that you include? But it was felt that these were the most sensitive information. Having done that, this was then sent, I sent it in a letter to Chief Judge Lippman of the State of New York Court of Appeals, Chief Administrative Judge Fowl. It was then sent to a CPLR advisory committee, which I was fortunate enough to also be on. The CPLR advisory committee has now sent to the Administrative Board of the State of New York a modified version of what we proposed at the City Bar. And interestingly, as a whole, that advisory committee took a much stronger view. They said, it's not enough information. It's too little, there has to be more. So they have recommended Social Security numbers, telephone numbers, date of birth, driver's license number, non-driver photo identification card numbers, employee identification numbers, mother's maiden names, insurance or financial account numbers, demand deposit account numbers, savings account numbers, credit card number or computer password information, electronic signature data or unique biometric data, such as a fingerprint, voice print, retinal image or iris image, or medical procedure, diagnosis, or billing codes. That's a lot. But the CPLR Advisory Committee said, we want to protect sensitive information, and we want to make it mandatory. It said the courts should have the ultimate responsibility to determine whether something should be removed, and they have the ability to do that upon motion. Matrimonial litigations were excluded. One group that has asked for a modification are consumer debt cases. A lot of times with sewer service, people buy debt and they sue people, and those people, if you leave this information out, don't have the ability to know whether they're really being sued for something they did. It's been requested that in this case, the last 4 digits, for example, Social Security numbers, be allowed. But the point is, when you're looking at this and you're realizing all the issues that comes up, and then you have the fact that there are a lot of people, fairly, that say, wait a minute, we have a First Amendment right to have access to information. We want to have access and there be as little restriction as possible. So what's going to happen now, I think we'll know in the next few months, hopefully. Will the administrative board approve this? If they do, it will be the first time in New York State that there will be a statewide rule for which attorneys will be responsible in filing their papers with the court. Thank you.
Jay, thank you. Our next presenter also comes from the Eastern District of New York. Robert Hanneman is the clerk of that court. He's held that position since 1983. Before that, he was a chief deputy clerk and pro se staff attorney. He received his JD from Brooklyn Law School and a JD from Fordham University. He has received the Director's Award for Outstanding Leadership from the Administrative Office of the United States Courts. Mr. Hanneman.
Thank you. And I want to thank Judge Ratchett for inviting me to this discussion. As a clerk of the court, I have a more general perspective about this. And first off, I'm very aware that I'm a public information officer, kind of like between the court and the public. At the same time, I'm also aware that I have to be a gatekeeper, a temporary gatekeeper. I'm one who are temporary in deference to the press, because I also am a public information officer that relates into press inquiries. And I think the internet is really our helper here, although it's been a hard way to get there at times. I agree with what was said earlier in another panel, I think it was by Judge Morris, that scanned documents are problematic. I would much rather always have an electronic document. I think electronic documents are easier to temporarily seal and completely seal if it's done appropriately, and limited to certain views by parties in court, and it's also easy to unseal it. Because, you know, the flip side of all of this, and I think courts do a very, very good job in the criminal area, and sometimes a less good job in the civil area, is in unsealing documents. When someone is indicted before they've been arrested, or there's a safety or security issue, for a very brief period of time, that information or indictment is sealed. As soon as that person is arrested or the reason for sealing it is gone, almost immediately the court directs the court to unseal that. I think that happens less often in civil litigation, where there is more of a desire on the part of one or more parties to seal a settlement agreement or to seal some corporate information. I'm not talking patents or other matters like that, that often may need to be sealed and stay sealed at times. But I think courts can do better in terms of unsealing matters that they've already sealed. But there are a lot of practical issues. I won't go over what was put in my brief statement, but except briefly, we have to comply with the federal rules, and each district, it's important that they have local rules of policy. Eastern District of New York has one. It should be transparent as to why a document is being sealed. There should be an order of approval to seal it by the court. I think that form we've developed in Eastern New York is useful for that purpose. It also is very important, and here's where the problem comes in, where the rub is, to always use that form, or to always make it clear why a document needs to be sealed, however briefly, or if it's the rare case that may have to have a long-term seal. And that's where human error comes in. And we have to do our best as public servants and as members of other agencies of the government to eliminate human error and as those who are. A core question for this committee may be, who ultimately is responsible to be a backstop to redaction. I certainly don't think it should be the clerk's office in the first instance, but maybe it should be the clerk's office in the last instance. Attorneys do get busy, attorneys will make errors, the U.S. Attorney's Office will make errors, the clerk's office will make errors. But at some point, since this area is so important in terms of privacy and in criminal cases protection and safety, someone has to be accountable as a backstop. That will not make human error zero, but it will certainly maybe make it less likely because there's another pair of eyes looking at it. And that brings me to another point that I touched upon in the statement. I think we need more help with software in terms of flagging potential areas where something should have been sealed that may have been missed. Because we do have quality control deputies, and that's a very important role now. The clerk's office has changed enormously over the last 10 years even. From going to a very paper-intensive office, we'll always have paper, but where every item was paper, to now where everything is potentially on the internet is filed by an attorney very quickly. And that's both a beauty, and I think it's a help. It's also something that needs very careful control and monitoring. And so, to the extent that the administrative office can provide us with additional software tools, they do a great job right now. But if we can have some additional search that might be possible to be done to flag certain categories of docketing that we would look at more closely, since we have so many thousands of documents to look at in every situation, that would be very helpful. Another obvious thought is that, courts can have local rules on a variety of matters, and they do, and they need to have them. They can have local policy. But even with changed federal rules of procedure, I think it takes a good 2 to 3 years before the practicing bar really, in general, gets very familiar with those federal rules of procedure and starts to use them, daily and uniformly, and are aware of them. Which means that clerk's offices have to do much more to be proactive, to put more on our website, to flag things in ways that make it available and right under the nose of counsel. Because if it takes 2 to 3 years for counsel, and with all due respect, to get really familiar with the federal rule, imagine how much longer it takes counsel and the clerk's office and other government agencies to get familiar with local rules of policy, administrative orders, which often are the most effective and efficient way to do something quickly, but also may be the least well-known or well-understood. So we have to use our public websites to call attention to those in a very proactive way, in a way that you see it immediately as what to do on your website. As soon as that administrative order goes out there, or policy, procedure, or form. So those are some of the things that I think clerk's offices can do to help the court police these matters, which are only really policed in the short term, and only maybe 1 or 2% of the filed matters before they are, once again, in most instances, open to the public. Thank you.
Thank you. Our final speaker is Joe Goldstein. He's a freelance reporter, former courts reporter for the New York Sun. He's currently working on a project for ProPublica, a nonprofit investigative newsroom. Mr. Goldstein.
Hi. About the only thing I'm qualified to talk about here is how reporters actually use electronically filed documents. I used to have a desk in the U.S. courthouse in Brooklyn when I was writing for the New York Sun. And I figured that most of my stories would be based on courtroom events that I actually witnessed, trials, arraignments, and sentencings. And on occasion, the courthouse will have a good trial, and that will keep the reporters nourished for a couple of weeks. But I was struck that there's a lot less courtroom action than you might actually expect. Criminal prosecutions, even the good ones, generally end in plea deals, and none of the evidence that sort of the prosecutors have amassed ever comes out in the open court. And the point here is that a robust right of public access to the court needs to encompass more than just the right to sit in on court when there's a judge on the bench. Reporters rely very heavily on PACER to figure out what's actually going on. A huge share of what we write about comes from documents filed electronically, attachments to those documents, and the like. And I'm trying to think of an example to illustrate this, but you may remember the name of Russell DeFreitas, who was indicted on charges of trying to blow up part of JFK Airport. The case broke in June 2007, and he's been in court a handful of times since then, but certainly the case is still going on, and very little has actually emerged in open court. If you log on to PACER and sort of run a docket search, you'll see that as of last night, it was 192 motions, letters have been filed. And you can bet that most of the reporters in the Eastern District have read every single word of that. And it's really from that they're able to follow one of the more important cases that's currently winding through that courthouse. I'm unclear on what proposals, if any, are on the table to further redact court records, to seal additional court records, but I would like to say I'm probably against it. From this spectator's point of view, one of the main functions of courts is to provide sensitive personal information for people. And this is not an incidental function, this is what courts do. And much of what emerges in proceedings or in attachments filed on PACER do contain sensitive information, terribly private information, people's deepest, darkest secrets. And the public has a right to know, and this information ought to very much be in the public domain. At the sentencing of a murderer, for instance, the widow might talk about how this is traumatized her children. And just because the names of minors are disclosed, that does not mean that a transcript ought to be reflexively redacted or sealed. A defendant who doesn't want to go to prison for the rest of his life may tell the court a tale of woe about his ill health. He may provide medical records. He may provide psychological records. He may talk about abuse that he suffered as a child. And just because that is sensitive medical information doesn't mean that it should be reflexively sealed or kept private. It will factor into the sentence that the court makes, and the public ought to have a right to inspect also the actual basis of that sentence. There seems to be concern that information filed electronically will be used for nefarious purposes. I believe that we've heard that there are instances of identity theft from bankruptcy proceedings. I'm not very familiar with that, but I would like to know more about instances in which we know that information filed on PACER or filed electronically has been used to do wrong. I want more than just sort of an undifferentiated fear. I've read in the past about concerns that criminals will use electronic access to courts to access information about potential cooperators or co-conspirators and use it for purposes of witness intimidation. I'm not aware of any such cases. Maybe they do exist, but I think the court should have a couple in hand before they act on that fear. I don't want to be too provocative, but I will say that last year in Brooklyn, an attorney was sentenced for trying to facilitate hits on a couple of witnesses. A defense attorney in New Jersey was indicted on a similar sort of thing just last year. And so my hunch, and I don't know for sure, that defendants who want to use information that comes out in court to kill off those who might testify against them are generally getting their sources of information from discovery or from confidential information that never ever gets filed publicly. So I would caution against just being worried that the public has access to motions in the like that are filed electronically, that would suggest that that some of this information might be used to intimidate witnesses and the like. And I'd just like to close by saying that, especially in the civil context, a lot of documents are already filed under seal. And documents that could simply be redacted are instead just filed under seal. And there's been talk about needing a backstop to make sure that Social Security numbers and other identifying information isn't put into, isn't filed. I'd also, the backstop that I'm interested in seeing is a backstop of judges and court officials who make sure that civil attorneys, the attorneys engaged in civil litigation aren't just filing documents under seal because it's more convenient and they'd rather litigate privately than let the public have access. And my hunch is that a good portion of the documents that are filed under seal need not be. And I'll close with that.
Joe, thank you. Any questions? Anybody have a question? If so, give your name and I guess I have a question. I don't want to keep anybody from lunch, but you know, Judge Strong talked about the need to search for perfection here because the stakes are so high for some folks, particularly in bankruptcy, and yet we've got an exemption for pro se filers. And you know, and I've been told, the Ninth Circuit has the civil docket is 40% of the cases in the Ninth Circuit have a pro se participant, 25% in the Western District of Washington, where I'm from. Should we be doing something for those folks, and if so, what?
Well, I can tell you that from the narrow and, well, as a practitioner, I can assure you that none of my clients was ever pro se. But moving to my role and my perspective in bankruptcy court, where both debtors and creditors, other parties in interest may file pro se, I don't see a reduced risk of harm to a person who doesn't have a lawyer in their Social Security number being electronically accessible in the docket. And however you give effect to that concern, I don't see a principal basis to make a distinction in the kind of harm you're trying to avoid. Now, it's a lot easier to have a framework to instruct lawyers and require lawyers, for example, to file electronically, unlike pro ses who bring paper to the counter which is scanned, to base your requirements on that system. And I would not want to create administrative traps for uninformed people trying to navigate a sufficiently complex process already by somehow creating impediments to the ability to file a case. But I think your concern is spot on. There is no difference whatsoever. In fact, maybe even more harm could be done to a self-represented person through the inadvertent inclusion of Social Security information, Social Security numbers on documents they file in the case. I certainly make no distinction if I see them in the docket. If I see them simply ended up in court, I see it in the proof of claim. We attend to it the same way. And I have taken the spirit, if not the letter, of the Judicial Conference policy and the requirements that we implement through CMECF to be that this information should not be publicly available. How we do it is through the requirements on lawyers through CMECF and otherwise. Why we do it, I think, would make no difference whatsoever whether there's a lawyer or not. So I think I'm agreeing with that.
Professor, last word.
Yes. And aware that I'm standing between you and lunch. I think there are some things that can be done technologically to help pro se filers avoid mistakes of this sort, to scan their filings and be a little more aggressive about pointing out possible issues. As well, if you can ask them to fill out up front a fairly simple form that might depend on the type of case they have, in which they explicitly list information, for example, in bankruptcy case, information about their Social Security number and bank accounts. And that could help to target a technological scan for information that ought to be redacted, which can then either be done for them or it can be suggested.
I will just note with the same concern about sitting between you and lunch, the number is 9 Social Security numbers that were found in those documents that were viewed in pro se papers. My speculation is that every single paper that comes in, and I do mean paper, at the clerk's office counter is reviewed for this purpose. That's the only way I can imagine we're getting to a number like 9, and these so many pro se pages at a time. Thanks so much.
All right, thanks to the panel. Professor?
Thanks very much for the panel.